Good morning. Are we ready to begin?
I am ready, Your Honor.
Yes, Your Honor.
Good morning. We're here today for the in-custody arraignment calendar. Today is Sunday, March 29th. Are there any special requests regarding the order of today's proceedings or requests for continuances before we begin?
No requests on the order, Your Honor. I do have a couple of requests for continuances due to Marcy Law, but I think we can just handle those as they come up.
Thank you, defense.
Your Honor, no special requests. I do understand we have an interpreter matter, though.
Thank you. Yes, we will go and head to the interpreter matters first. And so next we will call Juan Gutierrez, followed by Remigo Macedino.
And this is Jimena Fini, Certified Court Interpreter Spanish, NVF XP 610. Good morning.
Good morning. We're here today for first appearance bail hearing. Probable cause has been found in the public defender's office, has not yet been appointed to represent the defendant.
Buenos días, estamos en la primera comparecencia inicial. Se encontró de que hubo motivo fundado. El abogado de oficio aún no ha sido nombrado.
Mr. Gutierrez Cervantes is present utilizing the services of a previously sworn and certified Spanish interpreter.
El señor Gutiérrez Cervantes está presente y está siendo asistido por la intérprete jurídica que ha sido juramentada anteriormente.
Sir, do you wish for this court to see if you qualify for the services of a public defender?
Señor, ¿quiere ver usted si acaso usted cumple los requisitos para que se le nombre un abogado de oficio?
Sí, está bien.
Yes, that's fine.
Thank you. So assuming you were to remain in custody, are you able to make any money?
Ok, bueno, gracias. Si usted puede permanecer en custodia, señor, ¿puede usted pagar algo de dinero?
Sí,
Yes.
How much are you able to make while in custody?
¿Cuánto puede pagar de fianza mientras está en custodia?
de aquí o de afuera. Y de dentro.
From here or outside?
In custody at the Washoe County Jail.
Mientras está detenido en el centro de detención de Washoe.
Yo tengo 1,300 en mi cartera.
I have $1,300 in my wallet.
Thank you. I do find that you qualify for the services of a public defender, so the Washoe County Public Defender's Office will be appointed to represent you.
Ok, gracias. Yo veo que usted sí cumple los requisitos para que le puedan nombrar un abogado de oficio de la oficina de los defensores públicos de Washoe.
The court is in receipt of the Nevada pretrial risk assessment, which indicates that the defendant scored as a 7 or moderate risk utilizing that tool.
Ok, bueno, yo veo de que usted entonces se le hizo la evaluación previa al juicio y que usted sale con un puntaje de 7 o moderado.
State, please proceed with your request.
Por favor, Fiscalía, proceda con su petición.
Your Honor, we are asking for $5,000 bail and supervision in this case.
Su señoría, pedimos $5,000 de fianza y supervisión en este caso.
We would ask for testing if that is possible.
También vamos a pedir evaluación si es posible.
The defendant's history is primarily DUI related.
Los antecedentes del imputado son relacionados principalmente por manejar en estado de ebriedad.
I show his first conviction in 2004 for DUI in Waukegan, Illinois.
Yo veo que su primera condena fue en el 2004 en Waukegan, Illinois.
His prior that forms the basis of the enhancement here was from a case that occurred in 2022 and he was convicted in early 2023.
Yo veo que aquí tiene un caso de que era por agravante del 2022 y su condena fue a principios del 2023.
And he also had a conviction last year for assault that was down from domestic.
También veo que acá tiene una condena por agresión y que se lo habían bajado porque había sido un caso doméstico.
With this defendant, it appears that alcohol has been at issue for quite some time given his DUI convictions.
Por lo que veo acá con este imputado, el consumo de alcohol ha sido un problema, también basándose con su condena del DUI por sus siglas en inglés.
And so based upon that risk to the community, we believe that bail is appropriate and ask that you set it as requested. Thank you.
Basándose en ese riesgo de él por esos tipos de cargo que tiene, pensamos de que entonces la fianza sí es apropiada que se fije en este caso. Gracias.
Defense, please proceed.
Por favor, defensa, proceda.
Your Honor, I am asking for an OR release today for the following reasons.
Su señoría, yo pido que lo deje salir bajo palabra de honor por las siguientes razones.
For that NPRA, we did confirm his address.
En la evaluación previa al riesgo confirmamos su domicilio.
It's an interesting situation when you look at the NPRA because it brings it down by 1 because he just recently moved to a new address.
Es una posición interesante porque al verlo de la evaluación es por uno porque él tiene un nuevo domicilio.
But the prior address before that, he lived there for over 3 years at that time.
En el domicilio anterior, él vivió como 3 años en ese entonces.
He has been in the area for 28 years.
Él ha estado en el área por más de 20 años.
So he has been in the Reno area for most of his life.
Por lo tanto, él ha estado en el área de Reno por la mayoría de su vida,
showing substantial ties to this community along with an entire family that is financially dependent on him.
También tiene lazos en la comunidad y una familia que depende únicamente de él.
On top of that, we did confirm his employment. He has been a construction worker for the past 25 years.
También nosotros pudimos verificar el empleo y él ha estado en la construcción por más de 20 años.
So with all that information, we do have him scoring at now a 5.
Con toda esa información, entonces su puntaje ahora sale un número 5.
The least restrictive means to ensure safety to the community as well as ensure his ensure future appearances is an OR release from what I'm seeing right now.
Entonces, el medio menos restringivo que es para asegurarse de que él vaya a comparecer y la seguridad de la comunidad sería que a él lo dejen salir bajo palabra de honor.
I do not see a history of failures to appear, meaning that he does take care of his matters with court.
Yo no veo faltas de comparecencia, lo que quiere decir el de que él sí se encarga de sus asuntos judiciales.
Thank
He
you,
also-
defense. Can you proceed with the whether or not you agree with any of the conditions?
Gracias. ¿Puede por favor decir si acaso usted está de acuerdo o no con las condiciones?
So, Your Honor, we have no objection to drug and alcohol testing.
Su señoría, no tenemos ninguna objeción a él que le hagan pruebas de alcohol y drogas.
Unless the court has any other questions, I will submit on that.
A menos que su señoría tenga alguna otra pregunta, con eso lo dejo a su criterio.
Thank you. The court does find that there are least restrictive means that can be ordered in order to ensure the safety of the community.
Gracias. Creemos entonces el medio menos restringido para poder entonces conservar la seguridad de la comunidad.
So, sir, you will be released here today.
Señor, usted saldrá en libertad hoy día,
You
Gracias.
are required to
Thank you.
comply with these conditions.
pero se le requiere de que usted cumpla con estos requisitos.
You are ordered to be supervised by pretrial services and must check in within 24 hours of release.
Usted se le va a pedir de que usted tenga supervisión con los evaluación previa al juicio y que usted tiene que reportarse en las 24 horas hábiles.
You cannot possess any controlled substances or alcohol or use any of those unless you have a valid prescription, including for marijuana.
Usted tiene, señor, tiene que abstenerse de cualquier consumo de alguna sustancia ilícita o alcohol, a no ser que sea una receta médica, ni tampoco marihuana.
You will be required to be subjected to daily alcohol testing.
Usted se va a requerir de que a usted le estén haciendo pruebas de ver si está consumido alcohol a diario.
And it will be for alcohol only, that the court has not heard information regarding controlled substances.
Y esto será solamente por alcohol, ya que no tenemos información de alguna sustancia ilícita.
I am requiring that you conduct what we call the DUI rant.
Voy a pedir también entonces de que usted tiene que hacerse la evaluación de riesgo por DUI por sus siglas en inglés.
I do find that there is a nexus for all these conditions based off of your criminal history and the allegations.
También veo de que hay aquí, se adjunta con los antecedentes penales y este tipo de caso.
Additionally, I will note that pretrial services or PTS shall remove testing and supervision if you are a low risk.
Voy a también aquí anotar de que usted entonces tendrá que, cuando se le haga la evaluación del riesgo y depende de lo que sale, entonces será usted removido y será fijado como un riesgo bajo.
And that is due to least restrictive means and community safety.
Y eso es en el medio menos restringido y también para la seguridad de la comunidad.
We will set your arraignment, which will be set for April 16th at 9 a.m.
Fijaremos entonces su instrucción de cargos para el 16 de abril a las 9 de la mañana.
You must appear in Reno Justice Court on that date and time, as well as comply and appear for all future court appearances.
Usted tiene que comparecer ese día aquí en el Tribunal de Justicia de Reno y en todas las audiencias en el futuro que se le digan.
You must comply with these requirements as well as obey all laws, or else a bench warrant will be issued for your arrest.
Usted tiene que cumplir con todos estos requisitos que se le han dicho, señor, o si no, se va a dar una orden de aprehensión en su contra.
Do you understand?
¿Entiende?
Sí, claro.
Yes, of course.
Thank you. That will be the order of the court, and that concludes this hearing. Thank you.
Gracias. Esa será la orden judicial y eso concluye esta audiencia. Gracias.
Gracias.
Thank you.
Next, we have Remigo Basadinho, followed by Clemencia Hunter.
Siguiente, Remigio Basiquinio.
And Your Honor, I'm sorry, can I get the name one more time?
Last name Macedinio.
Thank you.
Good morning. We're here today for first appearance bail hearing.
Buenos días, estamos aquí en la primera comparecencia para ver la fianza.
Probable cause has been found and the public defender's office has been appointed to represent the defendant.
Se ha encontrado motivo fundado y se le ha nombrado un abogado de oficio para que lo represente.
Just for the record, the defendant is present utilizing the services of a previously sworn and certified Spanish interpreter.
Para que conste en acta, él está presente, detenido y está siendo asistido por la intérprete jurídica que ha sido juramentada anteriormente.
The court is in receipt of the Nevada pretrial risk assessment, which indicates that the defendant scored as a 5 or moderate risk utilizing that tool.
Se ha hecho la evaluación de previa al juicio y él salió con un puntaje 5 moderado con esa tabla.
State, please proceed with the bail hearing.
Por favor, Fiscalía, proceda con la audiencia de fianza.
And Your Honor, if I may first inquire, so one of our Spanish investigators has been listening to phone calls the defendant has made. It appears that the defendant and the victim may also speak another dialect. I know my investigator was able to communicate with the victim, but said she spoke somewhat broken Spanish. So I want to double check that the defendant understands or that we are able to communicate with the defendant.
Thank you.
Su señoría, quiero decir primero de que yo tengo un investigador que había estado escuchando algunas de las llamadas y se ve de que él parece ser de que habla algún tipo de dialecto, entonces mi investigador se comunicó con la víctima y parece que sí. May the interpreter ask, Your Honor?
Yes, please. Thank you so much, Madam Interpreter.
Señor, ¿usted entiende bien el idioma español? ¿O qué idioma habla usted?
Habla Mosco.
¿Perdón?
Moscow.
A Mosco.
A Moscow.
Thank you, Madam Interpreter. I'm going to have you be on standby right now. And Madam Clerk, are we able to, on a separate line, get the interpreter through, I believe it's AIT, to see if we could get the appropriate dialect?
See if someone's available, Judge, if you just give me one moment.
Thank you.
Español también, ¿no?
Sí. Más o menos.
I'll just note that I heard something in terms of the respective, do you speak Spanish a little bit? And he was waving his hand indicating it, kind of.
Yes.
Does he understand Spanish, Your Honor?
What I heard, again, just it was in Spanish, but it's my interpretation that there was a question as to, in essence, does he understand some Spanish?
Más o menos?
And he indicated más o menos.
Okay.
And Judge, that dialect is not available on the language line.
Thank you.
¿Puede ayudarme? Para ayudar.
If I may, very briefly, I think he understands some Spanish. We were speaking Spanish together. And ¿puedes hablar español, sí o no?
Poquito.
He can speak some Spanish, he said.
Thank you. So I'm going to, just for the formality of today's proceeding, I am going to inquire through the interpreter. as to just, if I could have all the parties just hold on one moment.
Ok, vamos a esperar un momento, señor. Vamos a hacer esto.
So, sir, we are here today for bail hearing.
Señor, estamos aquí hoy día para una audiencia para fijar fianza.
Do you understand Spanish enough where you are comfortable going forward here today?
¿Entiende usted lo suficiente de español para poder continuar con la audiencia de hoy?
We have tried to get an interpreter in your dialect, but none is available right now.
Hemos intentado encontrar un intérprete en su dialecto, pero no tuvimos la suerte hoy día.
We can try this again later this morning, or I can continue this hearing until tomorrow to make sure that you are able to understand.
Podemos continuar esta audiencia para más tarde o mañana para asegurarnos de que usted entienda.
No, claro que sí, ahorita.
Of course, right now.
Ahorita.
Thank you. So I'll just note all of the information provided from defense counsel as well regarding the ability to speak with the defendant.
Bueno, gracias. Entonces voy a poner aquí notas acerca de toda la información que me ha dado la defensa en cuanto a lo del imputado.
And sir, if you do not understand a word that the interpreter provides to you, make sure to let her know and ask for clarification.
Señor, asegúrese de que si hay alguna palabra que su intérprete diga y usted no entiende, usted lo diga.
Madam Clerk, if we could please note the dialect for our record.
Actuaria, por favor, coloque notas acerca del dialecto para nuestras actas.
And we will go ahead and proceed based off of the request of the defense.
Vamos entonces a proceder a petición del imputado.
I am in receipt of the Nevada pretrial risk assessment as we discussed, which is a 5.
Como había dicho yo anteriormente, tengo acá la evaluación previa al riesgo de Nevada que salió con un puntaje 5.
State, please proceed.
Por favor, proceda, Fiscalía.
Yes, Your Honor. In this case, we are asking for $25,000 bondable only bail.
Gracias, Su Señoría. Nosotros en este caso vamos a pedir una fianza de caución de $25,000.
We were able to speak with the victim in this case.
Pudimos hablar con la víctima de este caso.
Again, her Spanish was a bit broken, but my Spanish interpreter was able to provide notes here.
De nuevo repito, el español estaba un poquito quebrado, pero mi intérprete en español pudo tomar unas notas.
She did say that she wants him released and wants the charges dropped.
Dijo que ella quería que los cargos ya no pusieran cargos en contra de él y que lo dejaran en libertad.
The notes indicate that she did not contradict what she had told law enforcement, but that she clarified he won't do it again.
Las notas dicen de que ella no es que contradiga lo que ya le había dicho a la policía, pero él dice que él no va a volver a hacer eso.
And she said she's not planning on obtaining a TPO.
Y dijo ella también que no planean tener una orden de protección en contra de él.
Given the facts of this case, however, the state is going to be asking for a no contact order pursuant to NRS 178, such that it's a new and subsequent offense.
Dado los hechos de este caso, nosotros íbamos a pedir una orden de no contacto con ella de acuerdo a la ley vigente de Nevada 178.
While the defendant does not have any criminal history, it's also clear from the facts that he has only been in the United States for less than a year.
Mientras el imputado no tiene antecedentes penales, él ha estado aquí en los Estados Unidos por menos de un año.
Given the facts in this case, the state is extremely concerned for the victim's safety.
Dado los hechos del caso, la Fiscalía está preocupado por la seguridad de la víctima.
Additionally, Given the lack of stability in this community, I would note also appears that the couple's daughter is in Mexico. There is reason to believe this defendant is a risk of flight.
Además, dado la falta de estabilidad que él tiene aquí en el sector, también sabemos que la hija de la pareja está en México, por lo tanto creemos que hay riesgo de huida.
I'm unclear. I did not see that there was an ICE hold or anything yet, although there's concern that if that does come into place, that he may be taken from this jurisdiction without the resolution of this case.
Además, creo de que él aún no tiene una orden de detención con inmigración, ICE en inglés, pero si eso llegase a pasar, él va a ser tomado, sacado de la jurisdicción y el caso va a estar sin resolver.
And so in addition to the bail and the no contact per NRS 178, we are also asking that he have supervision, no weapons, and remain in Northern Nevada.
Por lo tanto, pedimos fianza, una orden de no contacto de acuerdo a la ley NRS 178, de que él además esté con supervisión, que no pueda portar ningún arma aquí mientras está en el norte de Nevada.
And with that, I would submit it, Your Honor.
Y con eso lo dejo a su criterio, su señoría.
Thank you, defense.
Your Honor, I'm going to be asking for an OR release today.
Gracias, defensa. Su señoría, voy a pedir una que salga bajo palabra de honor hoy día.
The information I have shows that he's been in the area for 2 years.
La información que yo tengo dice que él ha estado en el área por 2 años.
And this is his first lifetime arrest, showing that he does not have a history of this type of conduct.
Y esto es su primer arresto, lo que quiere decir que él no hay antecedentes de este tipo de conducta anteriormente.
We did confirm his address as well, which he has been at for the past month.
Hemos confirmado el domicilio que ha estado en el último mes.
So that brings his NPRA to a 4.
Por lo tanto, eso baja a la evaluación de riesgo a un puntaje 4.
We also just confirmed that he did recently start a new job, bringing his NPRA further down to a 3.
También confirmamos nosotros de que él tiene un nuevo empleo, lo que aún lo baja más a un 3.
So he scores a low on the NPRA.
Por lo tanto, el puntaje que él sale en la evaluación de riesgo es bajo.
Any allegations that he might flee the jurisdiction to Mexico is pure speculation at this point.
Cualquier acusación de que él vaya a ser huida a México es nada más que especulación en este momento.
Looking at all that, since he scores so low, an OR release with a no contact order is appropriate at this time.
Con todo eso, ya que su puntaje es bajo, que se deje salir bajo palabra de honor y se dé una orden de no contacto sería suficiente en este momento.
And I'll submit on that.
Y con eso lo dejo a criterio de la jueza.
Thank you. The court does find that there are least restrictive means that can be imposed in order to ensure the safety of the community.
Gracias. Creemos entonces que el medio no restringido que se pueda imponer es para la seguridad de la comunidad.
So, sir, you will be released here today.
Señor, usted va a salir en libertad hoy día.
Hoy.
You will be required
Today?
to be, yes, you will be required to be supervised. I'll have it, yes, supervised by pretrial services.
Sí, señor. Usted va a ser supervisado con los servicios previos al juicio.
And you must check in with pretrial services within 1 business day of release, so this Monday, tomorrow.
Y usted tiene, señor, que reportarse con la evaluación previa al riesgo después de un día hábil que ya sería para mañana lunes.
I am requiring that you cannot possess any firearms or weapons as this is an alleged crime of violence.
Voy a requerir de que usted no puede portar ni ser dueño de ninguna arma de fuego, ya que este tipo de delito es un delito violento.
I am also going to require that pursuant to this judicial release order, you are to have no contact with the named victim.
También voy a pedir que en la orden de que usted va a salir en libertad, usted no puede tener ningún tipo de contacto con la presunta víctima.
So that means that you cannot contact the named victim and must stay 100 feet away from her.
Lo que quiere decir que usted no puede tener contacto con la víctima y tiene que mantenerse alejado 100 pies de ella.
Cannot contact her in any way, including by phone, text, email, electronic means, either social media, either directly or through an agent. That means someone working on your behalf.
Y usted no puede tener ningún tipo de contacto con ella, ya sea por teléfono, mensaje de texto, a través de una persona, correo electrónico, los medios sociales. No puede usar ningún agente tercero para tratar de comunicarse con ella. Nada.
State, can you please confirm the name? What this court has is that it's first name Citlali, last name Lopez, Lopez.
Fiscalía, por favor, puede confirmar. Yo tengo acá que es Citlali y el apellido Lopez.
Yes, Your Honor, that is correct. And I have her address if the court wants to include that as part of the no contact order.
Sí, su señoría, eso es correcto y también tengo el domicilio si acaso la jueza quiere poner eso también como parte de la orden de no contacto.
Thank you. The court will include that. So, sir, you are required to stay away 100 feet away from this location as well.
Sí, gracias. Vamos a incluir también entonces eso y usted tiene que mantenerse alejado 100 pies de ella y de ese lugar.
And state,
It-
please proceed with that address.
Por favor, fiscalía, proceda con ese domicilio.
It is 2284 Flag Drive.
Es la 2284 Flag Drive.
And just for the record, is it FLAG or FLAGG?
FLAGG.
FLAGG.
Thank you.
Gracias.
That will be the order of the court. So your first or your next appearance will be for an arraignment, which will be set for April 16th at 9 a.m.
Ok, señor, entonces esa será la orden. Su próxima comparecencia para su instrucción de cargo será el 16 de abril a las 9 de la mañana.
You must appear in Reno Justice Court on that date and time, as well as make all future court appearances.
Usted tiene que comparecer ese día a esa hora en el Tribunal de Justicia de Reno y también comparecer en todas las audiencias en el futuro.
You are required to comply with these conditions and obey all laws, or else a bench warrant will be issued for your arrest.
Señor, usted se le pide de que usted cumpla y obedezca los requisitos y las leyes, o si no será usted vuelto a arrestar.
Sir, do you understand?
Señor, ¿entiende?
Sí, claro que sí.
Yes.
Thank you. Just for the record, the court is not imposing the other conditions requested by the state, as I don't find that there's a sufficient nexus to require them.
Ok, gracias. Y entonces para que conste en acta, la jueza no va a ordenar ninguno de los otros requisitos que habían sido mencionados anteriormente.
And that concludes this hearing. Thank you, Madam Interpreter.
Y eso concluye la audiencia. Thank you, Your Honor.
And I believe that is all of our cases with you. Appreciate your
Thank you.
time here today.
I'm gonna stay for 5 minutes to observe a little bit. Thank
Perfect. Thank you. Next, we have Ronix Cespedes,
So,
followed by, go ahead.
Your Honor, they refused again today. I understand you wanted us to do the arraignment today, but I'm not able to do that because they refused. I could proceed with the bail hearing though.
Thank you. We'll go ahead and waive the defendant's appearance for today's proceeding. We will just address the bail hearing. The arraignment will be continued until tomorrow at 9:30 a.m. The court is in receipt of the Nevada pretrial risk assessment, which indicates the defendant scored as a 14 or high risk utilizing that tool. Just to confirm, defense counsel, are you able to proceed, or are we doing an interim bail?
Your Honor, could we do an interim bail? I wasn't able to speak with them.
Thank you. State.
So I know that yesterday the request was due to illness. I'm not sure if we have that information. If he's just refusing today as a second day, we would ask that it be
It will be interim bail. Thank you.
Okay. Yes, Your Honor. So with Mr. Cespedes, we're asking for $10,000 bail, pretrial supervision, and testing for alcohol and controlled substances, no contact with the Dick's Sporting Goods. The defendant has a lengthy criminal history, as is probably made clear by his MPRA score of 14. His history goes back to the early 2000s, has been in the state of Nevada, recently distinguishing himself with drug charges as well as failing to appear. So in 2025, he had 2 different failure to appear arrests as well as a misdemeanor conviction for obstructing a radio municipal court. 2023 had a possession of drug paraphernalia in this court conviction, had arrest for probation violations. Also had a misdemeanor conviction for destruction of property in Elko. 2022, he had a felony conviction for possession of a controlled substance in the 4th out in Elko. Misdemeanor conviction for false statement obstructing and petty larceny in Elko. 2021 also had a possession of controlled substance conviction in Elko. 2018 false statements to obstruct in Elko Township.
Thank you. State, I'm inclined it's based off of we are not having a valid 10 minutes hearing. I'm inclined to follow the request.
Okay.
If that assists.
Sorry. Yeah. So the 10,000 pretrial supervision testing and no contact with Dick's.
Thank you. That will be the order of the court. So it'll be a $10,000 bondable bail with a 10% cash option. It will be an intermediate bail. I will require that the defendant be supervised by pretrial services and must check in within 24 hours of release. I am imposing the condition that he cannot use or possess or have under and use any controlled substances or alcohol, as well as be subjected to random testing. I do find that there's sufficient nexus based off of the criminal history. I will just note that additionally, he must stay 100 feet away from Dick's Sporting Goods. That will be the order of the court, and we will set that 72-hour hearing, which will be, I apologize, we won't set that. We will, as we indicated, we will have that arraignment tomorrow. Thank you.
And Judge, I'm sorry, we don't have a complaint for him.
Okay, that makes so much more sense. I did not see that. So we will just set that interim bail and we will set that 72-hour hearing for April 3rd at 9:30 a.m. Thank you. Next, we have Clemencia Hunter. And Madam Clerk, can you confirm that the alternate public defender's office is not present?
That's correct, Judge. They are not present and they did not respond to my email.
Thank you, ma'am. So unfortunately, we cannot proceed here today. Good morning. We are here today for a bail hearing and arraignment, but we do need to have your counsel present. So we will continue your matter for tomorrow at 9:30 a.m. Thank you. Raul Arolo, followed by Joshua Belcher. Good morning. We're here today for first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 12 or a higher risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. So in this case, we are asking for $10,000 bail, pretrial, no contact with either Miss Angelica Nunez or the address 5560 Kitsky Lane. The defendant has lengthy criminal history going back to 2007, primarily out of state in Minnesota. She had a gross misdemeanor conviction for disorderly conduct. It's all in, much of his conduct appears to be in Hennepin, Minnesota. I think that's around Minneapolis. Also had a 2012 DUI and obstructing conviction in Minnesota. 2014 violate domestic violence TPO in Carver County, Minnesota. Misdemeanor conviction for domestic assault and obstructing in Scott County, Minnesota. Another misdemeanor conviction for DUI in Carver County, Minnesota. They call it DWI apparently in Minnesota. 2015 misdemeanor conviction for disorderly conduct in Brawling, Minnesota. 2016 trespass and possession of drug paraphernalia here in Reno Justice Court, but he also has convictions in Minnesota for domestic assault and gross misdemeanor conviction for obstructing in Minnesota in that year. Had a 2020, it looks like it's a gross misdemeanor conviction for DUI third in Minnesota. Then he had a 2022 felony conviction for domestic assault in Minnesota, a 23 misdemeanor conviction for disorderly conduct in Minnesota, He had a misdemeanor conviction, damage to property in Minnesota in 25. It looks like he also has a domestic violence TPO case that there's a warrant, but it's non-extraditable out of Minnesota. And then he earlier this year had an open container of alcohol that's pending with no disposition. So this defendant has reflected a pretty lengthy and continuous criminal history for about 20 years now. While he had that 2016 case here, it's unclear to the state really what his contacts are, given that he was recently in Minnesota again and has that open case with a warrant. So based upon that activity, his lack of ties to the community is undealt with cases in another jurisdiction. The state submits that he has proven that he is a risk to the community. With his prior criminal conduct, he is a risk not to appear, and therefore 10,000 with supervision and the no contacts are appropriate. We'd also ask for no weapons, given the fact that he is a convicted felon. With that, I'd submit it.
Thank you, defense.
So, Your Honor, I'm going to be asking for $5,000 bail, but also a 10% cash option to give him some skin in the game if he is able to bail out. An alternative, I would ask for an OR release to direct treatment for substance abuse, just given his criminal history and also the way this case came about. I do think that that would be something that would be beneficial to him. Unfortunately, he has been only in the area for about a month and a half, so that's why we're not able to establish any connections with the community. So given all that, I am asking for the $5,000 option or direct transport to treatment, and I'll submit on that.
Thank you. Based off of the facts as presented in the Nevada pretrial risk assessment and the factors as outlined in NRS 178, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the safety of the community. I will note the lack of ties to this community, the likelihood of conviction, the significant threat of harm to the community based off of the allegations is contained. And so bail will be set in the amount of $5,000 bondable with a 10% cash option. If the defendant is able to post that bail amount, I will require that he be supervised by pretrial services and must check in within 24 hours of release. So this 24 hours after he is released. State, please confirm the spelling of the name of the victim, that there will be a no contact order and he will stay 100 feet away from that named victim.
Yes, so it's Angelica, A-N-G as in golf, E-L-I-C-A. Nunez, N as in November, U-N as in November, E-Z as in zebra.
Thank you. The court does find that that is appropriate. I'm not including the address as requested. I don't have sufficient information to find that that's appropriate. Additionally, I will note that the court will require that the defendant cannot possess any firearms or weapons based off of his criminal history. I do find that that is a least restrictive means. The court did consider a direct transport to an inpatient treatment facility. However, although it may be beneficial for him, the court does not have information to determine that that is the least restrictive means that can be imposed in order to ensure the safety of the community or the appearance of the defendant. So that will be denied at this time. The court will set a 72-hour hearing, which will be set for April 3rd at 9:30 a.m. Thank you. Next, we have Joshua Belcher, followed by Spencer Finhill. Good morning. We're here today for first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as an 8 or a moderate risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. So again, the defendant scores an 8. I show that he has a misdemeanor conviction for battery in the Reno Municipal Court in 2023. Given the allegations in this case, the state believes that some bail is appropriate. We'd ask for $2,500. We'd also ask that the defendant comply with any CPS or HHS reunification plan. Given his relation, I'm unclear what involvement he may necessarily have in that. Obviously, we'll see the child's mother later, but given that CPS is involved, we'd also ask that he be subject to pretrial supervision and comply with the CPS or HHS. With that, I'd submit it.
Thank you, defense.
So, Your Honor, I'm going to ask for an OR release in this case. Looking at the facts of this case, he is not associated with the child's mother or anything in that type of relationship. This is basically the mom asked him to take care of the child. Child was asleep, then he fell asleep, and then in that time, the child let themselves out. So there's no allegations of violence or anything like that in this case whatsoever. What had happened was he was trying to help the mom out who was working, and unfortunately that happened. He's not a threat to the community whatsoever or anything. CPS is not going to be involved with him. Given all of that, he's going to come back to his future court appearances. I don't think there's a reason to keep him here in custody. So with that, I am asking for an OR.
Thank you. The court does find that there are least restrictive means that can be imposed in order to ensure the safety of the community. So, sir, you will be given an owner cognizance release here today. You will be required to be monitored by pretrial services. So you must check in with pretrial services within 1 business day of release, which would be Monday, this Monday. You are required at this time, I am imposing the condition that you are to have no unsupervised contact with a minor child with initials A.G. I do find that that is, unless approved by the Human Services Agency or HSA, commonly referred to as CPS. I do find that that is appropriate in order to ensure the safety of the community. That will be the order of the court, and we will go ahead and set your arraignment, which will be set for April 16th at 9 a.m. So you must appear in Reno Justice Court on that date and time, as well as all future court appearances, obey all laws and comply with these conditions, or else a bench warrant will be issued for your arrest. Do you understand?
Yes, Your Honor.
Thank you. State, just given the defendant's status with the minor child, the court does not have information in order to find that HSA would be working with the defendant. So at this time, the court's not imposing that condition. If that becomes appropriate, the court is happy to reconsider it. However, the court doesn't have facts that that is a least restrictive means or there's an nexus to require it at this time. Thank you. Next, we have Jeanette Fuller, followed, or my apologies.
What?
Next, we have Spencer Finhill, followed by Jeanette Fuller. Good morning. We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 6 or moderate risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes. In this case, we're asking for $3,000 bail, pretrial supervision, and testing for alcohol and controlled substances. So show a 2009 conviction, misdemeanor conviction for battery, 2011 misdemeanor conviction for reckless driving, which was down from a DUI, obviously concerning given the facts of this case. Then I show that he has a felony arrest for possession of a controlled substance in Story County from 2025 that I don't show a disposition for yet. Unclear if that's still outstanding or if just not entered on the record. So given that prior history of DUI a number of years ago, as well as the recent possession of controlled substance case and now this DUI case, it's clear that Mr. Finhill has had substance abuse at issue in his life for some period of time. Obviously concerning given the child in the vehicle when this occurred. And so based upon the risk to the community from these types of crimes, as well as the concern for reoffending given the recent PCS, possession of controlled substance, we believe bail is appropriate as well as the supervision. That I'd submit it.
Thank you, defense.
So, Your Honor, I'm going to be asking for an OR release because I do believe there's other conditions that could be fashioned to ensure future court appearances as well as safety to the community. We did confirm that he has a job with Google and he has on USA Parkway, the new site that they are opening up, and he has been there for about 6 to 8 months. So that brings his NPRA to a 5 medium. We also did confirm his address as well as we did confirm his phone number as well, his landline. So that brings it down further to a 4, showing that he is a low, he has a low chance of leaving and not coming back and handling his court matters. I believe that drug and alcohol testing is entirely appropriate in this case. But other than that, he is not a threat to the community as long as he is sober, and he knows that if he doesn't do what he's supposed to do, he will be yanked right back into custody. Looking at all this, Your Honor, I am asking for an OR with drug and alcohol testing, pretrial supervision as well, and I'll submit on that.
Thank you. The court does find that there are least restrictive means that can be imposed in order to ensure the safety of the community. So, sir, you will be released here today. You will be required to check in with Reno Justice Court within 24 hours of release. So that means on Monday, you must come to Reno Justice Court. You are ordered to complete the DUI grant. So when you go to Reno Justice Court tomorrow, you can set that up. You will be required to do 3 mutual support groups per week, and you are ordered to provide those proof of those 3 mutual support groups per week to Reno Justice Court by every Friday. Just for the record, that is things such as AA meetings, the NA meetings, the non-secular version, or any of those smart recovery groups. You are ordered to not use any alcohol or controlled substances. However, I'm not ordering testing at this time. So just to make sure that is clear for the record. You will be required, as I don't find that there's a sufficient basis given the information provided. What I will do as well is require that you come here for your arraignment. So you must appear in Reno Justice Court for your arraignment on April 16th at 9 a.m. You must make all court appearances, as well as obey all laws and comply with these conditions, or else a bench warrant will be issued for your arrest. Do you understand?
Yes, Your Honor.
Thank you. Next, we have Jeanette Fuller, followed by Luisa Garcia. Good morning. We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 5 or moderate risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. So with Ms. Fuller, we're asking for $5,000 bail, pretrial supervision, comply with CPS or HHS. With Ms. Fuller, her criminal history has a misdemeanor conviction for battery in 2020. That was down from child abuse or neglect. In reviewing that case, it looks like that involved another child of Ms. Fuller, and there was an allegation of a bite to the cheek in that case. Looks like it was ultimately pled down to battery. Obviously concerning, given now, approximately 6 years later, and the child was approximately 4 or 5 years old at the time of that incident, the child from the prior case, which is similar in age to the child in this case. Concerning in that, the allegations of neglect, house issues, also the allegations regarding the child having melatonin and other things, trying to keep him asleep. What's concerning about this case is that it's apparent that the child was left in Mr. Belcher's care for quite some period of time. That apparently was the plan, is just leave the child with Mr. Belcher while Mr. Belcher was sleeping, which obviously led to this scenario. As far as the child wandering the streets. Concerning, given the prior case, the risk to this victim specifically, and so therefore the state is asking for bail and those conditions. Thank you.
Thank you. Do you have any other, I heard one prior history just as to why bail is necessary, and that just a no contact order is insufficient for least restrictive means.
Your Honor, so that is the only conviction she has. I think as far as bail, it's frankly, it's obvious she has multiple children. It's unclear where the other child is, given the risk and the fact that this has happened again. We believe she's a risk to the community, but that's the only conviction we show.
Thank you. Defense?
Your Honor, I'm asking for an OR release. There is definitely least restrictive means to ensure safety to the community as well as ensure future court appearances. The other child's with the father. CPS is involved. definitely right now, CPS is going to be monitoring her and making sure that she is taking care of the child. I mean, right now, the child's not even in her care. The child's with CPS. So there's going to be a bunch of things that she's going to have to do. And it's going to be much better for the child as well as her as she is able to come out of custody and handle the requirements that CPS is going to give to her. If she remains in custody, she cannot do anything to better her ability to take care of this child. Unfortunately, what happened was not great, but this is a big wake-up call for her. Keeping her here in custody is just going to further damage her ability to take care of this child and damage her ability to thrive later on when this case is done. She has been in the area for 29 years, showing that she has substantial ties to this community. She has been employed for Sam's Club for the last month as well. So, Your Honor, with all of that, I do think an OR release is entirely appropriate with the condition that she comply with any orders that CPS gives her, and I will submit on that.
Thank you. I'll just note for the record that today's standard is not what is much better for the defendant. And so I just want to make sure that's very clear of what the court is finding is that there are least restrictive means as the state has not met its burden by proving by clear and convincing evidence that there are no least restrictive means in this case. So ma'am, you will be given an own recognizance here today. You will be required to comply with these conditions. You are ordered to be supervised by pretrial services. So you must check in with pretrial services within 1 business day of release. So this Monday. You are ordered to comply with all HSA, Human Services Agency requirements. You are also ordered to have no contact with any minor children without approval from the Human Services Agency. I do find that those conditions are necessary in order to, for community safety, as well as least restrictive means. That will be the order of the court, and we will set a arraignment on April 16th. At 9 a.m. So you must appear in Reno Justice Court on that date and time for your arraignment, as well as comply with these conditions, make all future appearances and obey all laws, or else a bench warrant will be issued for your arrest. Do you understand?
Yes.
Thank you. Next, we have Luisa Garcia, followed by Kagan Kimes. Good morning. We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 4 or low risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. So with Ms. Garcia, I don't show any prior criminal history. I show she's a 4. We're not objecting to an OR here. We'd ask that she be supervised and have testing for controlled substances and alcohol. Notably, she had the psilocybin allegedly in her purse. It also asks that she not have any contact with the Silver Legacy and the Row casinos, which are all owned by the same company, to the state's knowledge. With that, I would submit it, Your Honor.
Thank you. Defense?
Your Honor, I will not object to those conditions.
Thank you. The court does not find that all those conditions are necessary at this time. So just for the record, the court will grant an own recognizance release here today. I will require that the defendant be supervised by pretrial services. So you must check in with pretrial services within 1 business day. So tomorrow, Monday. You will be required to have no contact and stay 100 feet away from all of the Row casinos. Just to make sure it's clear for the record, that includes Circus, Silver Legacy, El Dorado. You are required to complete 3 mutual support groups per week. Those are things such as NA, AA, or the non-secular version, and provide proof to pretrial services by every Friday, just while this case is pending. I will require that you cannot possess or that you cannot use any controlled substances or alcohol, but I'm not requiring testing at this time. I don't find that there's a sufficient nexus, and I note the allegations in this case, but I don't find that that's necessary at this time. That will be the order of the court. We will set your arraignment, which will be set for April 16th at 9 a.m. You must appear in Reno Justice Court on that date and time, make all future court appearances, obey all laws, and comply with these conditions, or else a bench warrant will be issued for your arrest. Do you understand?
Yes, Your Honor.
Thank you. Next, we have Pagan Kimes, followed by Oscar Loza Manriquez. Good morning. We're here today for first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 4 or low risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. In this case, we're asking for $25,000 bondable only bail. It's a DUI third allegation concerningly, also with the hit and run, essentially concerning given that he was driving poorly enough that he left the roadway, which is obviously a risk to the community. Had the extremely high PBT in this case. What is also concerning is that the defendant's history, as the DUI third charge indicates, is related to DUIs. So he had his first DUI conviction in 2016 in the Reno Justice Court. He also was convicted of a DUI second and the Sparks Justice Court that occurred in August of 19 and was convicted in November. He had a misdemeanor conviction for DUI in South Lake Tahoe in 2024. And then he also had another arrest in South Lake in 24. It looks like it was dismissed in 25. So not only is he charged with the felony DUI third, this is his 5th lifetime arrest for DUI and appears to be getting worse in that fact that not only was there DUI, but extremely high BAC at this point and a crash. So this defendant's absolutely a risk to the community. And given the ramp up to the felony here, the state would submit he's a risk not to appear. And therefore, bail, pretrial supervision. We would ask for some sort of daily monitoring, such as OSM or an ankle monitor, given the relatively high BAC and the short order at which he's now had his, again, 2 arrests in 24, one that was ultimately dismissed, but now 26, so 3 arrests in the last 2 years. With that, I'd submit it, Your Honor.
Thank you, defense.
Your Honor, I'm going to ask for an OR release, or in the alternative, a nominal bail amount of $10,000 bondable. Looking at his criminal history, I mean, he does have DUIs, but he has been in the area for 12 years, showing that he has substantial ties to this community. He also does have a job at the pepper mill. He is a mixologist over there, and he has been there for about 8 years. So he has stable employment as well. This is not an individual who is going to go out and flee the jurisdiction because his entire job and family is here. Also, the risk of him not appearing due to this being a felony, that's complete speculation. What we have to go off of is his past criminal history, which does not show that he fails to appear. He always handles his court matters. He will be on drug and alcohol testing as well, showing that he will not be drinking. So he will not be an individual who's going to be drinking and continuing this type of conduct. Looking at how this case is going to resolve, it's probably going to resolve with the DUI diversion court, meaning that he, at this time, is not facing as much of a risk of going to prison as other individuals. He does have the risk, but he does have the ability to do the DUI diversion program. So, Your Honor, I do think there is least restrictive means to ensure safety to the community as well as ensure his future court appearances. That is why I'm asking for an OR release or, in the alternative, a bail an amount of $10,000 bondable, and I'll submit on that.
Thank you. Based on the facts as presented, the Nevada pretrial risk assessment and the facts as outlined in the NRS 178, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case. The court will set bail in the amount of $15,000 bondable with a 10% cash option. So if you're able to post that bail amount, you will be required to be supervised by pretrial services, and you must check in within 1 business day of release. I am ordering that you cannot use any controlled substances or alcohol unless you have a valid prescription. And I did not hear any nexus to require for controlled substance testing, so it will at this point be alcohol only, and you will be subjected to daily alcohol testing. That will be the order of the court, and we will go ahead and set your arraignment, which will be, my apologies, your 72-hour hearing, which will be set for April 3rd at 9:30 a.m. Just make sure it's clear. You would be required to comply with all of these conditions of bail laws and make all future court appearances. Do you understand that?
Yes, Your Honor.
And
Thank
Your Honor,
you.
if I may clarify, as far as I understood defense's representation, he's essentially I understand mixologist, but
I don't believe we need to get into that at this time. Thank you.
So is it no possession? Sorry, it's no possession or no use
It's
of?
cannot use. I will note my concerns regarding his profession. However, this court does not have the ability to discuss and go into that detail at this time. Thank you. Next, we have Oscar Loza Manriquez, followed by Freddie Mendoza Sanchez. Good morning. We're here today for first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as an 8 or a moderate risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. With Mr. Loza, we are asking for $5,000 bail, pretrial supervision, no use possession of alcohol, as well as testing for the same. The defendant has criminal history going back to 2014. I show a possession of drug paraphernalia case in that year with no disposition. Also shows a conspiracy failure to appear on bail after a felony with no disposition in Lyon County. That was in 2015. Has a disturbing the peace in Reno Municipal Court. Also has a felony conviction for attempted battery substantial bodily harm in 2019 here in the Second Judicial. Also has a DUI in Reno Municipal Court from 2019. Has a misdemeanor conviction for resisting in Walker River Justice Court in 2020. He was arrested on a DUI as part of that case. Looks like the DUI was ultimately dismissed and it was just the resisting. 2024, he had a domestic battery arrest where it was dismissed, and then 2025 had a resisting conviction in the Sparks Justice Court. So given understanding this is a DUI, he's got a fairly high score, and his history is replete not only with violence, obviously, as the convictions indicate, but also DUI and resisting. So this defendant's a risk to continue this conduct, risk to the community, and therefore we believe that bail and testing and supervision are appropriate. Thank you.
What is his open case in Sparks Justice Court?
Sorry, I don't believe he had an open case. He had a resisting conviction in 25, and then he had a domestic battery in 24 that was dismissed in Sparks Justice Court.
Thank you. Pretrial services indicated that he had a suspended sentence that was still pending in Sparks Justice Court. So he had a case pending.
So that must be the resisting, Your Honor, from 2025.
Do you have any information as to, is he on probation?
Sorry, Your Honor, I just pull that up. He
No.
Your Honor, Mr.
He was sentenced to 180 days suspended on the condition of obey all laws.
Thank you. Defense?
Your Honor, I'm going to be asking for an OR release today. Looking at his ties to the community, he has been in the area for 31 years, his whole life, and he also has been at the same address for 8 years, showing substantial ties to the community. He's also not an individual who is a risk of flight. When you look at the NPRA, he did not score anything on the failures to appear. He has dealt with his past matters, showing that he does make his court appearances. We also confirmed his job. He has been with Twisted Wrenches for about 3 years. He is a mechanic. We also confirmed his address. He has been there for at least 5 years. We also confirmed his landline as well, showing that pretrial services can get in contact with him whenever that is necessary. This isn't an individual who has ever had an issue with that in his criminal history. So looking at all that, Your Honor, we do see an individual that there is least restrictive means to ensure safety to the community as well as his future court appearances. We have no objection to alcohol testing as well. With that, Your Honor, I will submit.
Thank you. The court does find that there are least restrictive means that can be imposed in order to ensure the safety of the community. So, sir, you will be released here today. You will be required to be supervised by pretrial services, and you must check in within 1 business day of release. Just for the record, that'll be this Monday. You will be required to not use any controlled substances or alcohol unless you have a valid prescription. The court only heard information about alcohol, so just for the record, you will be required to be subjected to daily alcohol testing, and it will be for alcohol only. The court will require that you comply with these conditions. We will go ahead and just for the record, you will be ordered to do what we call the DUI rant. And just for the notation of you will, if it comes back from the DUI rant as a low risk, then pretrial services shall remove supervision and testing. We will set your arraignment, which will be set for April 16th at 9 a.m. You must appear in Reno Justice Court on that date and time, comply with all these conditions, make all future court appearances, and obey all laws, or else a bench warrant will be issued for your arrest. Do you understand?
Understood.
Thank you. Next, we have Freddie Mendoza Sanchez, followed by Devin Patterson. And just parties, just for the record of, we have a very lengthy calendar. Just want to make sure that's clear. Of the court's reviewed all the information several times, so just note that. Good morning. We're here today for first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates the defendant scored as a 6 or moderate risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. So with Mr. Mendoza, we are asking for $7,500 bail. The defendant has criminal history going back to 2009. He had an arrest for burglary here in Reno. I don't show a disposition for that. However, he was also given an alien admissibility in 2009. I know he has an ICE hold now. It says he was removed from the country in 2016. It looks like pending his alien admissibility action, he also had an arrest for DUI in 2012 that I don't show disposition for, and then a gross misdemeanor conviction for attempted possession of a controlled substance here in the second judicial in 2015. So again, it appears the alien admissibility was started in 2009, likely deported based on what I see after the resolution of the 2015 case. Given the allegations here, we're also asking for pretrial supervision and testing for controlled substance, no use of the same. With that, I would submit it.
Thank you, defense.
So, Your Honor, with this case, I understand he was OR'd originally, but then because of the ICE hold, they are asking for the court is wanting a bail on him. I don't
have that information. Is that in a separate case?
That's what I read on the NPRA information, that he was OR'd originally, but because of the ICE hold,
Okay, so that was not the court. He was eligible for an administrative release except for the hold. So that is why he was required to be seen by the court.
Yes, Your Honor, my apologies. So, Your Honor, I am going to ask for a nominal bail amount, just given the facts of this case. They had noticed him because there was a known gang member in the passenger seat. And because of that, that's where they got the probable cause to do the canine search and such. Looking at this, we have no idea whose drugs they actually were, because the reason why this came was because of the passenger in the vehicle. Because of that, I am asking for a nominal bail amount for about $1,000 or a 10% cash option. And with that, Your Honor, I'll submit.
Thank you. The court will just note for the record that disagrees with the recitation of the facts, as the information provided indicated that the car stop was regarding the registration issue. So I'll just note that for the record. The court does find that the state has met its burden based off the facts as presented in the Nevada pretrial risk assessment and all the factors as outlined in NRS 178, that bail is necessary in this case in order to ensure the appearance of the defendant. I will note the lack of ties to this community as well as that ICE hold. Based off of that, the court will set bail in the amount of $5,000. It will be bondable with a 10% cash option. So if you are able to post that bail amount, you will be required to be supervised by pretrial services. You must check in within 24 hours of release. And I am posing the condition that you cannot use or and have any controlled substances or alcohol and be subjected to random drug and alcohol testing. I do find that there's a sufficient nexus to require that to occur. We will go ahead and set that 72-hour hearing, which will be set for April 3rd at 9:30 a.m. So you must appear for that hearing as well as comply with these conditions. Thank you. Next, we have Devin Patterson, followed by Sheena Shepard.
Thank you. It does. Thank you. Ms. Patterson, right?
Good morning. We're here today for first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 14 or a high risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. So with Mr. Patterson, we are asking for $3,000 bail. The defendant has a lengthy criminal history. Going back to 1995 here in Nevada, most recently he had a misdemeanor conviction for petty larceny and trespass in 2024. Also had a couple failure to appear arrests. In 2022, he had a felony conviction for possession of a controlled substance third here in the second judicial, as well as a misdemeanor conviction for battery. Misdemeanor conviction for possession of drug paraphernalia in 21, gross misdemeanor conspiracy to commit assault with a deadly weapon in 2018. Again, has other misdemeanor and other criminal instances going back to 1995. Given the apparent random act of violence here, it's apparent that he was just frustrated about his own vehicle and decided to take that out on someone else's vehicle while they're driving, creating a serious risk to motorists and other people in the community who would have been injured had more serious damage or an accident occurred after that. We believe the defendant is a risk to the community and that bail should be set. And with that, I think pretrial supervision or Reno Justice Court check-ins at the minimum, but no other conditions. Thank you.
Thank you. And just to confirm, I did not write it down. Do you have, is this going to be the destruction of property? Is the misdemeanor or gross misdemeanor level?
I think probably misdemeanor, Your Honor. We'll need some more information as far as but I think probably misdemeanor.
Thank you. Defense?
Your Honor, I'm going to be asking for an OR release today. This is an individual who's been in the area for 26 years. He also has had a job at Reno Ace Stadium for the past 6 months, showing that he has substantial ties to his community as well as stable employment. I understand the facts of this case show this as it could possibly be a random act of violence, but this individual will be under pretrial supervision now and such, and at this time he is facing a misdemeanor, showing that there will be a possibility of this case being resolved pretty soon. So because of that, Your Honor, I do think that there's least restrictive means to ensure safety to the community as well as future court appearances. I think an OR release with pretrial supervision is entirely appropriate, and I'll submit on that.
Thank you. Just for the record, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the safety of the community and the appearance of the defendant based on the facts that presented the Nevada pretrial risk assessment. I will note the failure to appear is a lack of ties to this community and that history of violence. Bail will be set in the amount of $1,000 bondable with a 10% cash option. If the defendant is able to post that bail amount, Mr. Patterson, I am going to have you check in with Reno Justice Court within 24 hours of release based off of the information that this will be likely charged as a misdemeanor offense. I am ordering that you appear for, at this time, it'll be a 72-hour hearing, which will be set for April 3rd at 9:30 a.m. So if you are able to post that bail amount, you will be required to comply with all these conditions of bail laws and make all future court appearances. Do you understand?
Yes. Yes,
Thank you. Next, we have Sheena Shepard.
No.
Good morning. We're here today for first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. The court is in receipt of the Nevada pretrial risk assessment. And just for the record, it indicates that you scored as a 17 or a high risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. In this case, we're asking for $2,000 as well as supervision and testing for Ms. Shepard. She scores at 12, as the court noted. She has quite a bit of history. It's all out of state, which is the primary concern. She appears to have really no ties to this community. As recently as 2024, she was getting arrested in California. She had shoplifting cases in Pasadena and Upland, California. They look like they're both dismissed. But then prior to that, she was in the state of Florida. Her last conviction there was in 2022 for trespassing, and then had a number of other misdemeanor and other convictions going back in Florida. So again, essentially the lack of ties to the community indicates and I guess I would note also that she appears to have a trespass warrant from Las Vegas that's not extraditable. So she really has very little context with this area, and therefore, in the state's view, bail is appropriate to ensure that she appears in the future. We'd ask for that $2,000, and then supervision. Given the context, it's probably appropriate to have testing for controlled substances. If Ms. Shepard anticipates being a part of this community for a while and seeking help, I'd have no objection to the IAP transport.
Thank you. And State, I'm not holding you to this, obviously, but do you have any information as to whether or not this would be potentially charged as a misdemeanor? The court's just trying to determine whether or not a pre-sentence screening would be appropriate.
I think it's probably likely a misdemeanor.
Thank you. I appreciate that information. Would you have any objection if we set that pre-sentence screening? State, would you have any objection? If we
No.
set that? Okay.
Sorry.
Thank you.
I was contemplating or no.
No problem. I just wanted to make sure you could hear me. Thank you so much. Defense counsel, please proceed.
So, Your Honor, I am going to be asking for an OR release today. Looking at this case, it was a very small amount of drugs that was found on her, which is why the state is saying this is probably going to be resolved as a misdemeanor. That's what my inclination was too when I saw the amount that was found on her. Looking at her MPRA, although it's not great, the points that she does not have on there is from her lack of violent history, as well as her lack of felonies and gross misdemeanors, showing that she is not a threat to the community. Also, looking at the facts of this case, which I know the court has seen, she was on the side of the road. They were kind of doing their own thing. It's not like they were harming anyone. Obviously, the conduct is criminalized, but they were not harming anybody whatsoever. Looking at all that, I do think an OR release is entirely appropriate in this case, or an OR release direct transport if the court is not inclined to do an OR. With that, Your Honor, I will submit.
Thank you. The court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the appearance of the defendant. I will note the facts as presented, the Nevada pretrial risk assessment, as well as the failure to appear history and lack of ties to this community. Bail will be set in that amount requested of $2,000 bondable with a 10% cash option. This order will read bail or an OR, owner cognizance release through direct transport by IAP, DSU, or ASU to an appropriate treatment facility. The court does find that that is least restrictive means necessary in order to ensure the safety of the community. I will note also that this court will require that the defendant be supervised by pretrial services, so long as this is a felony offense, and that she will be required to be subjected to random drug and alcohol testing. So you cannot use any controlled substances or alcohol unless you have a valid prescription. I do find that that is appropriate given the facts and circumstances and the criminal history. So that will be the order of the court. The court will require and will set, not require, but the court will set a pre-sentence screening for cap court, as well as in a 72-hour hearing. That 72-hour hearing will be for April 3rd at 9:30 a.m. And Madam Clerk, please let me know when you're ready to provide the information for that pre-sentence screening.
The date today? Yes, Judge. It looks like the first available would be April 2nd at 9 a.m. for the PSS.
Thank you. So that will be set on the record, and we will go ahead and we've already set that 72-hour hearing, so we will see you back here in court then. Thank you. Next, we have Mark Atkins, followed by Julia Barham.
Your Honor, Mr. Atkins refused.
Are you able to proceed, or do we need a continuance?
We're going to need a continuance, Your Honor.
Thank you. I do find that there's good cause to grant a continuance in order for the defendant to be able to participate in the bail hearing. We'll just note we will conduct the first appearance here today. So we are here today for that first appearance. Probable cause has been found and the public defender's office has been appointed to represent him. We will continue the bail hearing for tomorrow at 9:30 a.m. Thank you. Next, we have Julia Barnum, followed by Joseph Figuera. Good morning. We're here today for two separate matters. We'll turn first to the first appearance bail hearing. Just for the record, probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 9 or a high risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. With Ms. Barnum, we are asking for $3,000 bail, pretrial supervision and testing. Miss Barnum has some older cases from the mid-2000s in California. However, what's most concerning, and I anticipate the court to address this in just a moment, but she has that possession of a controlled substance arrest that's currently pending in the Justice Court. She was ultimately charged with a possession of drug paraphernalia. However, she was OR'd in that case, I believe, and had the pretrial violation report because she had not been supervised for the approximate month before her hearing, and then she failed to appear. And so she also has a $3,000 bench warrant on that case. So, and I guess for the record, we're asking that stand they be consecutive, such as 3,000 and 3,000 with pretrial supervision. And that's based primarily on, again, the fact that she has proven herself unable to be supervised, but also clearly has a drug issue that has not been addressed in the last couple of years. So with that, I'd submit it.
Thank you. And then just for the record, do you have any objection to a direct transport or a pre-sentence screening?
No objection to an IAP. Just frankly, Your Honor, this is a close call given the fact that she didn't comply before, and it's sometimes difficult to know when people walk away. But given this is her second case in 2 years, and there was a pretty long gap, that's the basis of the non-objection to the IAP transport.
Thank you. And then just for the pre-sentence screening. Or do you need more information to determine that this could be satisfied as a misdemeanor? So you'd like to hold off on that?
No objection to pre-sentence screening either, Your Honor.
Thank you. I appreciate your courtesy with that. Defense counsel?
Your Honor, I'm going to be asking for an OR release, or in the alternative, OR release with direct transport to treatment. Looking at this case, it's not a case where she was a threat to the community or anything like that. The officer had recognized her, and then upon arresting her, found the methamphetamine that was on her. And it was a small amount of methamphetamine that was weighed with the packaging itself, showing that the actual amount of drugs was even less. With that, Your Honor, I do think an OR release is appropriate. She's not a threat to the community. If the court's not inclined, then I would ask for direct transport, and I will submit on that.
Thank you. Defense counsel, are you able to address that failure to appear warrant at this time, as well as the state's inclined and indicated that they were able to proceed?
Your Honor, I didn't get a copy of the warrant or anything. I mean,
you did. It was in the Pratt's. It was based off of the failure to appear, and there was the failure to comply concerns.
Sorry, Your Honor, I probably skipped over it because of all the matters that we had, but I can address it.
Thank you. And Madam Clerk, we can confirm that. I'm assuming the public defender's office was on that case. Just want to confirm that.
Yes, Judge.
Thank you.
And Your Honor, I'm sorry, I'm just moving to that right now.
Thank you. Appreciate that.
Okay, Your Honor, I have that warrant. I have it up now. Okay, I can address it. We're good. Yes. So
thank you. Please proceed.
So, Your Honor, with that, Your Honor, I'm sorry, you asking me to do the bail appearance on it? To do the bail. Thank you. So, Your Honor, I would have the same request as I did for the other case. I would ask for an OR release, or in the alternative, an OR release to direct transport. Looking at that case, it seems kind of similar, so I do think that's entirely appropriate. And I apologize. Sorry about that. And I'll submit.
No, I appreciate it, and I'm glad that we were able to address this here today. Just for the record, in the new matter, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the safety of the community and the appearance of the defendant. I will note the lack of ties to this community, the failure to appear in that other matter pending in Reno Justice Court. And so based off of that, as well as the likelihood of conviction, the court does find that bail is necessary in this case, and that will be set in the amount of $3,000 bondable with a 10% cash option. If you are able to post that bail amount, you will be required to be supervised by pretrial services, and you must check in within 24 hours of release. You are required to not use any controlled substances or alcohol unless you have a valid prescription, be subjected to random drug and alcohol testing. I do find that there's that sufficient nexus. Additionally, this order will read bail or an OR release through direct transport by IAP, DSU, or ASU to an appropriate treatment facility. That will be the order of the court, and we will set the 72-hour hearing in that case for April 3rd at 9:30 a.m. Now, in the other matter, the older matter pending on that warrant, the court does find that the state has met its burden. I will incorporate all the same findings of facts, and so based off of the failure to appear as well as the failure to comply, your own recognizance release is revoked. I am requiring that you have a bail imposed in the amount of $3,000 bondable with a 10% cash option. All of the same conditions will be for this case as well. So I am ordering that you be supervised by pretrial services, that you check in within 24 hours of release, that you be subjected to random testing, and that you cannot use any controlled substances unless you have a valid prescription. Additionally, I do find that there's a least restrictive means of an OR or own recognizance release through direct transport by IAP, DSU, or ASU. So just for the record, I am imposing that this is a bail or an own recognizance release through that direct transport. Your 72, we'll go ahead and set a mandatory status conference. I believe, Madam Clerk, can you confirm what the next setting is for that older case?
Yes, Judge, it'll be a second mandatory status conference set for April 8th at 9 a.m.
Thank you. That'll be the order of the court. And Madam Clerk, if you could please set a pre-sentence screening for cap court in both of these matters.
Okay, let me just make sure. I think the April 2nd date is still available, but let me just April 2nd. Let me just confirm.
Thank you.
Yeah, so both will be set for April 2nd at 9:30 a.m.
Thank you. And so, ma'am, you have a lot of court appearances. Just make sure that you have those dates, and that if you are in custody, you'll be transported, but if you're out of custody, you will be required to appear in person. Thank you. Joseph Figueroa, followed by Richard Callis. Good morning. We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 3 or low risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Your Honor, I will be asking for a continuance for Marcy's Law in this case. Unfortunately, I don't have an investigator on today, so we have not been able to make contact. I would note that I showed this as being an arrest yesterday after 2 p.m. So I do believe that tomorrow would still be within the 48 hours if we could move this to tomorrow. Again, I don't have the resources on today, given that it's Sunday, and so we're asking for 1 day to notify the victim so she can make her wishes known and appear if she determines that.
Thank you. Defense?
Your Honor, I don't think I have a basis to object for Marcy's Law, so we'll submit.
Thank you. I will just note that given the defendant's constitutional rights and the non-objection, we are still within the 48-hour time period if this is continued tomorrow. So the court is not continuing this on the basis of Marcy's Law due to the state not having an investigator. I will just note that we are still within the 48-hour time period. And so we will continue this for tomorrow until 9:30 a.m. Thank you. Richard Callis, followed by Louise Kretzinger. Good morning. We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as an 8 or a moderate risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. So with Mr. Callis, so I note also that he has another destruction of property case that occurred essentially on the same day. I show that as RCR 2026-134-769. In that case as well, I'm not sure if we're addressing both of those. I note that we received a request for a bail modification order, I believe, based on this offense.
Madam Clerk, can you confirm, I believe that was the one where pretrial services did not request any action, and so this court ordered for the district attorney's office or any of the parties, if they wish to address it, to file a written order or a written request?
Yes, yes, that's correct. We also have it on for an arraignment for tomorrow morning at 9:30.
Thank you. So the court
Okay.
will not be addressing that other matter at this time unless the state files a written request.
Okay. With this, the state is asking for $3,000 bail for Mr. Callis on this particular case. The defendant has, again, that other pending case that's also destruction of property. He appears to have fairly recent contacts with the state of Nevada. His history is primarily out of the state of California. Looks like he had a DUI arrest in 2014 in Pomona, California, that's still at warrant. Had a couple other DUI arrests in Santa Ana that were ultimately dismissed. Looks like he had a conviction in 1991 from when he was in the military for an assault charge. But given the relative lack of ties to the community, the kind of random act of violence here that's now multiple victims from that same day, he is a risk to the community in the states. We would also ask for Reno Justice Court check-ins. I will be awaiting some more information realistically, but it's likely that this would be also a misdemeanor charge. So Reno Justice Court check-ins would also be appropriate. We'd also ask for no contact. Sorry, I thought I had that address in my system.
I believe it was the Row Casinos.
Okay. Yeah, so no contact with the Row. Yes, it was at the El Dorado, so no contact with the Row, Your Honor. Thank you.
Thank you. Defense?
So, Your Honor, I'm going to be asking for an OR release with certain conditions that I believe can be fashioned to ensure safety to the community as well as future court appearances. I do believe a no contact order with the Row is entirely reasonable in this matter. Also, looking at his MPRA, I didn't see any points for failures to appear, showing that he is an individual who will make his future court appearances. He has been in this area for about 3 years, and he has been at the same address for 10 years. On top of that, he is a retired veteran. He is on VA benefits as well. With all that being said, Your Honor, I do think that this is an individual who should get an OR release with conditions that this court can fashion to ensure safety to the community, as well as future court appearances, which would be a no contact order or a stay away order from the Row Casino as well. Unless there's any other questions, Your Honor, I will submit on that.
Yes, the court does have questions just in essence of least restrictive means of, is he seeking services at the VA regarding anger management?
I can't. I'm happy.
So, Your Honor,
Okay.
So, Your Honor, he said that he's going to start seeking treatment from the VA right now for anger management and such. He said he can do that.
Thank you. I'll just note that the court is concerned regarding the criminal conduct, that it appears continues criminal conduct. I do find that there are least restrictive means that can be imposed in order to ensure the safety of the community. So in this case, you will be granted an own recognizance release here today. I will require that you be supervised by pretrial services, and so you must check in with pretrial services within 1 business day, so on Monday. I will just note that that is due to, since you are on pretrial services and on another matter, I do find that that is appropriate to then have you be supervised by one agency. I am imposing the condition that you cannot possess any firearms or weapons, as the information indicates that those tires were slashed. And so with that, I do find that there's a sufficient nexus to require, due to community safety, that you cannot use any control, or that you cannot possess or have under your custody or control any firearms or weapons. Additionally, I am imposing the condition that you must stay 100 feet away from the Row casinos. I am also ordering that you obtain a mental health evaluation, follow those recommendations. I do find that that is necessary as well as a least restrictive means in order to ensure the safety of the community. That will be the order of the court, and we will go ahead and set that 72-hour hearing, which will be set for April 3rd at 9:30 a.m. Thank you.
And I'm sorry, he was OR'd?
Correct.
So the arraignment date you want to set for April 3rd or?
No, I apologize. Arraignment will be set for April 16th at 9 a.m.
Okay.
And then Madam Clerk, can you confirm, hold on, before he leaves, hold on just one moment.
One more, sir. Sorry, my apologies. Come right back.
Please proceed, Madam Clerk.
He does not have the public defender appointed on this case or his other case either. Would you like his other case to be set for an arraignment on the 16th as well?
Hold on one moment. Let's address the public defender issue at this time. And so we'll go ahead and, sir, how much money do you make per week, if any?
Oh, myself, I just live off my disability from being a veteran. It's roughly $3,000 a month.
Thank you. I do find that you qualify for the services of public defender, and the Washoe County Public Defender's Office will be appointed to represent you in both matters. Madam Clerk, did you say that we have the arraignment set for tomorrow for an out of custody arraignment for the defendant in that other matter?
We have it set for an in custody because he was in custody, but we can set both for the out of custody on the 16th.
Thank you. State, does that work for you?
Yes.
Thank you. That'll be the order of the court. We'll see you back here then.
Thank you, ma'am.
Thank you, Madam Clerk. And next we have Louise Kretzinger, followed by Pedro Martinez. Good morning. We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that we scored as a 6 or a moderate risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. In this case with Ms. Kretzinger, we are asking for $5,000 bail, pretrial supervision, and no weapons. The defendant has a couple recent cases. She had a misdemeanor conviction for possession of drug paraphernalia in Reno Municipal Court in 2025. She also looks like she had a checks case, a non-sufficient checks case that was dismissed in 25. Prior to that, she had an arrest in the 80s that was dismissed. What's concerning here is obviously the behavior. She was essentially trespassing, asked to leave, and responded by pulling a knife and making threats, which is concerning. Risk to the community also shows, again, with the drug paraphernalia conviction in Reno Municipal Court in 25, looks like drugs, lack of stability in the community are at issue for Ms. Kretzinger. And so we'd ask for bail, pretrial supervision, and no weapons at this time based on what we have. Thank you.
Thank you. Defense?
Your Honor, I'm going to be asking for an OR release for Ms. Kretzinger because she has been in the area for about 55 years. Unfortunately, she has not had a dress just for the past 6 months. She's found herself on some tough times, unfortunately. She said if she is released, she does plan to go to a motel. She is only on Social Security benefits, and she does rely on government assistance, such as food stamps, to be able to pay for food and such. Looking at all of that, this is not an individual who really is a threat to the community. I understand the facts of the case are not great, but she does not have a criminal history of this. This seems to be like something that happened in that moment. Like I said, she's found herself on tough times. I think with all that, she should get an OR release with no weapons clause, as well as no drugs and alcohol. I do think there's a nexus just because of some of the criminal history. With that, Your Honor, I will submit.
Thank you. Based on the facts as presented, the Nevada pretrial risk assessment and the factors as outlined in NRS 178.4853, and the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the safety of the community. I will note the lack of ties to this community as well as the significant threat of harm as outlined in the probable cause declaration. I will note just for the record the defendant's own statements as outlined in that to support this request. Bail will be set in the amount of $5,000 bondable. Because of the allegations, there is no 10% cash option. If that changes, a defense counsel can proceed with the request to have this be readdressed. If the defendant is able to post that bail amount, I will require that she be supervised by pretrial services and must check in within 24 hours of release. I am imposing the condition that she cannot possess any firearms or weapons. Additionally, I am imposing a no contact order, so the defendant must stay 100 feet away from the Denny's location located at 680 North Wells. I do find that that is necessary in order to ensure the safety of the community and the named victims in this case. That will be the order of the court, and we will set the 72-hour hearing, which we set for April 3rd at 9:30 a.m. Thank you. Next, we have Pedro Martinez, followed by Benjamin Ray.
Mr. Martinez?
Good morning. We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 7 or a moderate risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Your Honor, this is another one we're going to be asking for continuance to ensure the victim has a say. I would note we're within the 48 hours at this time, as I show the arrest was yesterday on the 28th.
Thank you, defense.
Your Honor, I don't have a basis to object at this time, but yeah, I'll submit.
Thank you. Based off of the information provided and the defense submitting that the court does find that since we are still within the 48-hour time period, we will continue this for one business day. I will note that the court is not continuing on the basis of Marcy's laws. The information provided previously was just that the DA's office does not have an investigator today, and I don't find that that is sufficient good cause, but I will just note we are within the 48-hour time period. So this will be continued until Wednesday, until tomorrow at 9:30 a.m. Thank you. Next, we have Benjamin Ray, followed by Michael Roberts.
Yes. Did Mr. Ray refuse? He waived. I'm sorry, he waived, Your Honor. I'm so sorry. He waived. I'm prepared to proceed, though.
Thank you. Good morning. We're here today for first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent him. I am in receipt of the Nevada pretrial risk assessment, which indicates that he scored as a 6 or a moderate risk utilizing that tool. State, are you ready to proceed with the bail hearing? And just for your information, the court would like some additional information regarding the probable cause for the specific intent crime, as this is an attempted robbery. So we're robbery elements if the state is asking for any bail.
Yes, Your Honor. So the state is asking for bail for $5,000 bail. Your Honor, as far as the specific intent, the note he said this is a robbery, which I based on that statement, it caused concern from others. They had to create a perimeter to monitor the situation. It obviously created fear and concern with the staff around the casino. I understand that the note says, I love you and thank you, but he also says this is a robbery, which I think creates that requisite level of fear. The fact that he wasn't unable to get anything, I think, is where the attempt comes in. But given the note, we believe the elements are there. The defendant also, and just beyond the concern that this causes for a local establishment, the defendant does appear to have very little contact with this area. I show he had a reckless driving conviction in Vegas in 2012, as well as a DUI arrest with no disposition in 2012. And so the lack of ties to the community, the fact that he has no stability in the community, in the state's view, necessitates bail. And so we'd ask for $5,000 and no contact with the real casinos and no weapons, given the allegations here, and pretrial supervision. With that, I'd submit it.
Thank you. And just to make sure it's clear, with respect to what the court was inquiring about, as part of one of the elements is the by means or force of violence or fear of injury, immediate or future, and taking that property.
Yes, and so I guess the state's position is that putting a note in front of someone to saying that they're being robbed is that that fear of future violence. I don't think you have to have violence necessarily visited in a robbery. The threat of violence, and sometimes that's through a weapon or other means. But given the note saying this is a robbery, I think creates that fear. And again, the casino took action in setting up a perimeter, et cetera, which I think evinces that they were taking that very seriously, that threat of violence.
Thank you. And just to confirm, I don't recall hearing any criminal history.
Sorry, yes, he has a 2012 misdemeanor conviction for reckless driving in Las Vegas, and then a DUI arrest in Vegas in 2012 with no disposition. I think I recall that his NPRA indicates that he had moved from Vegas to Reno approximately a year ago, and it has no housing. So that's where a lack of ties to the community and lack of stability in the community, I think, comes in.
Thank you, defense.
So, Your Honor, this is a very interesting case. I don't think that they have the necessary elements to reach an attempted robbery because there's no force that was used or anything whatsoever. It's just the note that was passed, a note that says, I love you, this is a robbery. I will sit and wait, something along those manners. There's no use of force or anything here. Talking to the defendant today, he actually wants to remain in custody, which shows that there's some severe mental health issues and other things at work going on here. That's why I am asking for some bail, but I do not think $5,000 is sufficient. I'm going to ask for $1,000 because this individual is not going to be able to make any bail whatsoever. In fact, he doesn't want to make any bail. This is a cry for help, unfortunately. So, Your Honor, unless there's any other questions, I will ask for $1,000 bail, 10% cash option. Any conditions this court feels are necessary, such as a stay away order. With that, Your Honor, I'll submit.
Thank you. I'll just note that based on the stipulation of the defendant that bail is appropriate, the court will set bail in the amount of $1,000 bondable without a 10% cash option, as that's not permitted according to the charge. If the defendant is able to post that bail amount, I will require that he be supervised by pretrial services. And I am imposing the requirement that he check in within 24 hours of release. I am imposing the condition that he cannot have any contact and must stay 100 feet away from the rogue casinos, to include Circus, Silver Legacy, and El Dorado. I'm also imposing the condition that he cannot possess any firearms or weapons, as this is a crime of violence, or at least an attempted crime of violence. That will be the order of the court, and we will set a 72-hour hearing for April 3rd at 9:30 a.m. Thank you. Michael Roberts, followed by Jasmine Seaman.
Your Honor, Mr. Roberts refused with us today.
Thank you. Are you requesting a one-day continuance?
Yes, Your Honor.
Thank you. The court does grant a one-day continuance. I do find that that is necessary in order to ensure the defendant's ability to participate in the bail hearing. We will have the first appearance here today. Just for the record, probable cause has been found. The public defender's office has been appointed to represent the defendant, and so it will be the bail hearing that'll be continued until tomorrow. Jasmine Seaman.
Your Honor, same thing. Ms. Seaman refused with us. I am asking for a one-day continuance.
I do find that there's good cause for a one-day continuance. For the bail hearing, we will have the first appearance here today. Probable cause has been found, and the public defender's office has been appointed to represent her. So we will continue the bail hearing for tomorrow at 9:30 a.m. And I think that is everyone. Just want to confirm.
Yes, that's everyone, Your Honor.
Wonderful. Thank you all. I know this was a very challenging and lengthy calendar, so I appreciate your time and your attention to all the details in order to help make this run as smoothly as possible. Thank you.
Thank you, Anna. Have a great day.
You too.